परफेक्ट हो गया लगभग जी प्रोग्राम्स ठीक है थोड़ा इसका ऐसे करो अभी जी ऑडियंस दिखाओ प्लीज मेंटेन स्टूडेंट्स माइक ऑफ माइक स्टार्टेड
Very good morning to one and all present here. It's a very warm welcome to the dignitaries on the dais, respected faculty members, and my dear students to present here for the Silver Jubilee Endowment Lecture on Environment. As a part of this invocation, I now request everyone to rise for the prayer.
செய்பவர் நீயே மாண்புகள் நீயே என் தமிழ் தாயே வீழ்வாரை வீழாது காப்பவர் நீயே வீரனின் வீரமும் வெற்றியும் நீயே தாழ்த்திடு நிலையினில் உனை விடுப்பேனோ தமிழனின் நாளும் தலை குனிவேனோ சூழ்ந்தின்பம் நல்கிடும் பைந்தமிழன்னாய் தோன்றுடல் நின்னுயிர் நான் மறப்பேனோ செந்தமிழே உயிரே நருந்தேனே செயலினை மூச்சினை உனக்களித்தேனே நைந்தாயில் நின்னைந்து போகுமில் வாழ்வு நன்னிலை உனக்கெனில் எனக்கும் தானே முந்திய நாளினில் அறிவும் இல்லாது மொய்தலர் மனிதராம் புதுப்புணல் மீது செந்தாமரை காடு பூத்தது போலே செழித்த என் தமிழே ஒளியே வாழி செழித்த என் தமிழே ஒளியே வாழி செழித்த என் தமிழே ஒளியே வாழி.
Environmental laws is to educate about environmental issues and to make environmentally responsible citizens. I hereby quote that sustainability starts with you. To mark the official inauguration of today's program, I kindly request our distinguished guest, Professor Dr. Jitendra Kumar Das sir, and other dignitaries to light the lamp.
Checking channel.
Thank you, sir. I now invite Professor Dr. S. Srinivasan, Principal Dr. Ambedkar Government Law College, Puducherry, to deliver the welcome address.
Very good morning to one of us here. Respected Professor and friend, Dr. Jubilee Das, who is now head of the Department of Law, Dean Faculty of Law, University of Calcutta, and he is a part and parcel of the institution in all academic matters. My dear colleagues and my dear students, once again, very pleasant good morning. So today, we have all gathered here for the conduct of the Silver Jubilee Endowment Lecture on Environmental Law. So this lecture, Endowment Lecture, has been created on completion of 25 years. So as you all know that our college has crossed 50 years. We have conducted the Golden Jubilee as well. So now we have also proposed to constitute one such endowment for the Golden Jubilee on the new laws. Maybe it is our cyber law, IT securities, or any other law related to the security laws. We are going to propose now. So it gives me immense pleasure now today in the morning to be in the midst of a senior, I would say legend, because the first day I just met him, it was around 8 o'clock or 8:30. Met him in the department doing the work. So Mr. J.K. Das is such a senior professor and contributed his life and for the entire development of legal education in and around Calcutta. He's a very senior professor. And he had written so many books also on environmental law, on CPC, on human rights, and so many subjects. So we are privileged to have him here on this dais today. So when we have decided to invite somebody for this lecture, so we have all unanimously, the faculty members have found only one person as Mr. J.K. Das, most befitting person for delivering this lecture on environmental law. So on behalf of the institution, on behalf of the faculty members, and on behalf of my students, and on my behalf, I extend a hearty welcome to Mr. J.K. Das. I also extend up my hearty welcome to my friend, Mr. Cyril Matthias Wilson, who is on the dais, and who has been with me traveling with me right from the day, because we joined together as a faculty here, and thereafter he left. Now he's in the practice. And all three have been helping me for various academic matters. And you can just take it that because you are new to this institution, you may not know. But the people who have completed, they will know that he has been contributing for various academic matters, like practical trainings or special classes. So that way he is part and parcel of the institution. So for the reason that he is an alumni. So that interest has come only because he has been an alumni of this institution. So both myself and himself is alumni of this institution. So that way we have attachment to this institution, and he is with us in all academic matters. Similarly, today he is here. That he wanted to be with the students, and he wanted to be with the faculties and guests. So thanks for his presence here today. So once again, I welcome all of you on this occasion, and I request our senior professor, Mr. J.K. Das, to start his lecture.
Now it's the time to felicitate our esteemed guest. As a token of gratitude and respect, I now request our principal sir to felicitate our distinguished guest, Professor Dr. J.K. Das sir, Head and Dean, Department of Law, University of Calcutta, West Bengal. Thank you, sir. Thank you, sir. It's always a privilege and honor for a scholar to introduce their guide. And I now invite Mr. Saurav Dey, Assistant Professor, Dr. Ambedkar Government Law College, Puducherry, to introduce our chief guest, Professor Dr. J.K. Das.
Thank you, Rasatya ma'am. It's my great honor and privilege to welcome our esteemed guest as well as my guide, my everything. Because of him, his guidance, we are standing here. So, Professor Dr. Jatindra Kumar Das, sir, we have a great privilege that he consented to give this lecture on, Silver Jubilee Endowment Lecture on Environmental Law. Professor Das is a distinguished academician, currently serving as the Professor of Law, Head of the Department of Law and Dean Faculty of Law at University of Calcutta. With a career spanning decades, his expertise lies in constitutional law, international law, human rights, environmental law, and intellectual property rights, making him a leading voice in the legal fraternity. Professor Das' academic journey is truly remarkable. He holds an LLB from Guwahati University and an LLM and PhD from esteemed law school, Banaras Hindu University. Throughout his illustrious career, he held various key positions, including heading the Center for Human Rights and Citizenship Studies at West Bengal NUJS, Kolkata, serving as the convener of PhD Research Advisory Committee in Law at University of Calcutta. His commitment to shaping the future of legal education and research is reflected in his guidance of 16 PhD scholars and with 7 more currently under his mentorship. As an erudite scholar, Professor Das sir has made a profound impact through his research and publications. He has authored seminal works like Human Rights, Law and Practice, Law of Copyright, Code of Civil Procedure, and Human Rights and Indigenous People, etc. His contribution extends beyond academia, having served as a resource person for national and international seminars on critical topics including climate justice, intellectual property, and human rights. His recent project, funded by esteemed organization exploring into police system across various Indian states, reflecting his dedication to advancing social legal studies. Today, as we gather to explore into the complexities of environmental law, there could be no better guide than Professor G.K. Das sir. His work, such as human rights to development and protection of environment and rethinking climate justice in India, underscores his commitment to addressing pressing global issues through a legal lens. We are fortunate to have him here to illuminate the path forward in balancing development and environmental protection. Please join me in welcoming Professor Dr. J.K. Das sir to deliver this prestigious lecture. Thank you. Sir, seminar. Seminar.
Very good morning. I feel I have been honored by inviting me to be here. I recall 3-4 months before, Professor Dr. S. Srinivasan, principal of this college, he met me in my department at the University of Calcutta rightly around 8:30 p.m. this night. He proposed, I promised. I am very happy that proposal and promise is not enough. The performance is the main thing. I am very happy to come here that I have promised my performance. You have been told by many people that our specialization of this area, that in legal education, specialization is in your hand, and only specialization never works. If you are able to adjunct or connect all these areas together, it will work. Otherwise, it will not work. Law has two different aspects. One is substantive aspect, another is procedural aspect. Whenever substantive right linked with the procedure, it works. It is just like tube light. You put a switch, it will work, otherwise not. And if it is well connected, that will work. Otherwise, it will be a matter of joke. Now, in these words, first of all, I wish to acknowledge the government of Puducherry that's permitted me to come here. Proposal made by Professor Dr. S. Srinivasan, principal of this college. I convey my sincere gratitude and regards to all of them, as well as I wish to convey my sincere thanks to the faculty members of this college, as well as staff. My affectionate link with the students. I will be happy enough if my lecture is become useful for you. Therefore, I convey my sincere affection to all the students. So, when I am requested to deliver the lecture, I was agreed agree to speak on the environmental law. And this Jubilee Endowment Lecture on environmental law, I have decided that environmental law, human rights, and sustainable development idea and experience. Once upon a time, and there was no branch of law like environmental law. It is comparatively new. Initially, the law curriculum was only related with certain area of procedural and certain substantive law. There was no any branch of environmental law. Now it is well-established branch of environmental. Human rights was never taught in legal education. At least you know Indian independence. Before Indian independence, law was small, a diploma degree. Now legal education provides 5-year LLB degree, provides 3-year LLB degree, provides 2-year, plus as per the UGC curriculum, it is a full-fledged PhD degree. So it is totally an academic degree. and my lecture is oriented only to the only for the purpose of the students and academic purpose. Also, my lecture can be used for planning, environmental planning or lawmaking process. So, first three things is clear. What is to be clear? What is environmental law? What is human rights? And what is sustainable development? And which is the branch of what? Whether human rights is the branch of environmental law, whether sustainable development is the branch of human rights, or whether environment is the branch of human rights or environmental law, it is a contradictory issue. When I designed the lecture with a hypothesis or problem, the problem is surrounding with the three issues. One is right to environment is a right has been declared by the Supreme Court of India under Article 21 of the Constitution. Article 21 of the Constitution provides that no person shall be deprived from his life and personal liberty except the procedure established by law. Right? So, Article 21 of the Constitution, it is a fundamental right. It provides two aspects of law. One is substantive, that is right to life. It is a substantive aspect. Even if there is no provision, unlike Article 21, still every human being or other being have the right life. Tree has also the life, animal has the life. Also human being also have the right, that is life. Procedural aspect, we saw the procedural aspect by law, it is procedural aspect. It has been that Article 21 is a combination of the two aspects. One is substantive aspect, and then the right under Article 21 of the term. And right to development is another right under Article 21 as well. Because when Article 21 is expanded because of the international pressure and a large number of rights have been recognized all over the world in the civil and political rights and economic, social and cultural rights. But only the declaration of a right is not enough. It has to be realized and it has to be implemented. For the implementation, financial or economic resources are required. So, one right is linked with another right. So right to development is a right. So, number two, right to development has been insisted by the international community to be a right. So, to implement the right to development, large number of natural resources have been exploited. Activities have been taken place in Mother Earth. As a result, environmental pollution could have been started. Of course, environmental pollution, its control is not a new thing. It has been started right from the mythological period, like the period of the Kautilya Arthashastra in ancient India, or in Mahabharata, or in the period of the Gita, when Gita or Mahabharata dominated the Indian nation, Indian community, or Indian subcontinent. During this time, environmental pollution was there. I have the evidence. You may agree or not, but you can argue with me also, and I love to argue with you. So, as a result of conflict between the two rights, one is right to life and its implementing aspect or procedural aspect, the right to development. Still, right to development is the right under Article 21. That is, it is a part of the right to life. So, question is, whenever a law conflicting with the other law, which will prevail? It is basic question. You have studied very carefully, or oftenly your teachers has taught you in the class that fundamental rights and directive principles. Fundamental rights are enforceable because Article 32 is there. 32 itself is a fundamental right, as well as 226. There similar mechanism is there for remedy, legal remedy, right? If any fundamental rights are being violated, you may have the remedy and you can move to the court under Article 32 or 226. It is often. But in directive principle, directly you cannot move to the court because it is a non-enforceable right. So I understand wherever there is a conflict between the fundamental rights and directive principle, fundamental right will prevail. But nowadays, judiciary or Indian legal jurist, the jurist community, they are not agreed. They say that both the rights have the equal value, and it is one aspect and other aspect of one right, one side of a two coin, right? So gradually Indian judiciary has enforced upon directive principle also. So I understand this argument that if there is a conflict between fundamental right and directive principle. My second argument or question before we, if there is a conflict between two fundamental rights, which will prevail? It is not that I like this one, it will prevail. I don't like this one, that might prevail. There should be logic. There should be there should be some logic and reason, right? Because both the right, all the rights are at present the approach is to protect the right to life. So, what is this approach? What is the consequence of this approach? And another is, if I agree that everything should be protected in the word life, so what are the side effects? So in this background, I have designed my lecture into three major areas. One is historical aspect, right from the mythology, Mahabharata, Gita, and Indian ancient period, then British period, right? Because ancient Indian system, dharma and its system, still it is prevalent in the society. But during British period, they adopted another mechanism. They have not directly denied, but they have their own mechanism. But after Indian independence, Constitution of India has been adopted as the highest law of the land. So I recall a theory propounded by Professor Kelsen. He was the dean of the University of Austria. He developed a theory that which one is law, because everywhere every people will come and everyone will argue for their own interest against you that this is the law you implement, right? So which provision will be implemented? It is a question, or it is the issue even before the environmental law. Professor Kelsen said that law is a pure science. Law is a science. First one is the hypothesis is whether law is a science. He said yes, it is a pure science. How it is pure science? He said that a science. In a science, there is a relation between two things. The student and I am the teacher. The relation between two teacher students. So one party should be student, another party should be teacher. Then it is relation to teacher teaching relation. So if a science, he said that there is some relation between two things, right? So this relation is called scientific relation. But he has made a distinction between physical science and legal science. In legal science, the relation between two things is the what relation? If there is a crime, criminal ought to be punished. But not be punished, because if the criminal is a man, he will get the exemption. If the criminal is not a person, you will get exemption. But in physical science, the relation between two things is the is relation. How it is? Is relation is that if there is water, it is a combination of two things. H2 plus O is water. Relation between two things is relation. So if you express it, so very carefully you have to demonstrate. It is not that agricultural scientists demonstrate the poison and experiment. Poison is affected the law because their scientific product, agricultural product is harmful for the stomach and human being. Therefore new type of farming is started is organic farming, right? Unorganic farming because fairly respect because it is directly hit under Article 21 of the Constitution. So it is the experimental science, legal science is also experimental science. It demonstrated in the society and whether society tolerate it, accept it, appreciate it, survive. Otherwise, in the next election, they'll kick the political process out, they'll reintroduce another process. But there is no any possibility of agricultural science that how they kick it out. There is no clear cut. Therefore, our legal science is more established science. If you look into the Mahabharata, I'll put an example before you. That Bhishma, during the time of the war, he has laid down the rule of law. What is Article 21 today? He said that war will begin in the morning, it will end in the evening. Rati will fight with the Rati, authority will fight with authority. Man will fight with the man, woman with woman. How beautiful rule of law was there, Article 14, and all percent of Article 14 is covered with the rule of law declared by become official, mythological. It is not in existence today, but its rudiment principle still it is continuing. So in this way, I said, and environmental science, it is purely science. I'm going to deliver a lecture on environmental science, that is environmental law. how this law is successful or how not. It depends. One principle they conveyed in message that dharma. And entire society was regulated by a single principle, it is dharma. And if a thing is adharma, it is not a law at all. If it is dharma, that is, rudimentary principles of dharma, if it is fulfilled, then it is 21. That is your issue under Article 21. Satisfy the principle of Article 14 and 19. It is a good law. What is Article 19? In Article 19, freedom of speech and expression, several articles are there, but it is subject to the reasonable restriction under Article 19 clause 2. Right? Similarly, if somebody will come to you whether this law is a good law or a bad law, you have five principles in the law. That is, if these five principles are satisfied, then you are healthy. What are these principles? Art, light, and cosmos. And what was the mechanism to satisfy the art? In the ancient Indian mythology, there is a worship system. People used to worship the earth, Mother Earth. Water, Ganga puja hota hai, right? Similarly, air, Pavan puja hota hai. Similarly, light, Surya puja hota hai, Surya namaskar hota hai, this and that. Cosmos. What is cosmos? Vishwa Brahman. Shankaraचार्य say, Brahma Satya Jagat Mithya. That is, Brahma is the truth, and this world, Jagat, is Mithya. And he said that I don't have any scale or measurement by which I can measure the Brahma, that is cosmos. So there are five principles in ancient India. One example I will put before you, and the document is there. It is called Kautilya's Arthashastra. Right? Very famous book is published by Bombay University, Kautilya's Arthashastra, and Amartya Sen, in his delivery in London, when he became the master in Trinity Law College after awarding the Nobel. He cited the Arthashastra, right? And his argument he has developed because he has written a book on human rights. Idea of justice, and one chapter is there in human rights. And in justifying the human rights, he has his own arguments. It is half of the arguments I don't agree, some of the arguments I am agree. So in Kautilya's Arthashastra, it is clearly mentioned that in a city, if animals are dead, and if the dead body of the animal thrown in the city, and if the animals are dog, mongoose, snake, then it will be punished for 3 panas. During the Arthashastra, there are punishment systems. According to Austin, what is law? A law should have certain punishment, otherwise it is not a law. He said that law is the command of the subject backed by sanction. If there is no sanction, it is not law at all. But modern judiciary, they don't argue. For example, directive principle don't have the punishment provision. Still, it is law. Similarly, fundamental duties under the Constitution of India have no punishment. Still, it is a good law. So, Kautilya Arthashastra, he said that if certain animals are dead, an owner of the animal thrown within the city, these sort of animals, dead body of the animals, they will be punished by 3 panas. 3 panas during this time, one amount, for example, today rupees is there, taka is there, paisa is there, right? Penny is there. And if the size of the animals are higher, big, for example, as gada, and other certain animals, then the fine quantity of the fine will be 50 panas, right? So during this time, environmental pollution was there, definitely. Otherwise, why this could have been made a punishable offense, right? So in ancient India, there was a certain principle. Similarly, if you look into other than the Hindu mythology, if you take in the Islam, in India, Islam is not new. It has around 1800 years, right? Professed, practiced, and propagated. They said that in Islam, there is a very good principle that man and the nature are the creation of the God or Buddha, Allah, right? and nobody has the right to touch or disturb these things, right? So they are also Islam is also respecting the natural relation, and whenever your work will be against the nature, then it will definitely should have started certain side effect. So India also Buddhism is there. In Buddhism, there are ascetic matter, right? There are other things of peace, Santi, look Santi ka baat karte hain, right? And peace. If you keep the peace, the art or the nature, you will get the result. Now I am coming to another religion. It is the subsect of the Hindu. Under the constitution, Hindu also includes the Sikhs, but they have their own mechanism of professing, practicing, and propagating the religion. So Sikh Sri Guru Guru Granth Sahib, very famous Guru, he said that there are Panchatat. What is Panchatat? So you have to respect five principles. One is up, means water. Another is edge, means fire. Another is Vai, means air. Another is Piti, means earth. Another is Akash, Akash means sky, right? And one has to respect this Panchata. So what is environmental pollution and what is this rewarded is the surrounding with these principles. And definitely these principles are not respected, therefore this environmental pollution and other problems come. And today's modern world facing environmental pollution not that small thing. Its adverse effect is unimaginable. Acid rain, greenhouse effect, depletion of ozone layer, depletion of tropical rainforests. Acid rain is some acid is rain, something. It is totally scientific effect. So, one professor of English University, Professor Ima Tamali, she has observed by company Indian mythology religion. She said that in past Hindu and Buddhist were careful to observe the moral teaching of India. Whatever I thought, whatever I say in our literature is I am pointing out there are the type of moral teaching with the environmental effect. So you can argue that morality has no place in law. But if you argue in this way, so what should be Article 19? Article 19 clause 2 said that morality, essential morality, two things. That is, law has to satisfy the test of essential morality, right? Otherwise, the law will be declared by the competent court is not a law at all. Without moral content, no law can survive. So she said that moral teaching is very prominent in Hinduism, Buddhism, and in contemporary culture and contemporary century. The materialistic orientation of the world has created all the problem, right? Even Western people, they are also agreeing the fact that whenever moral principle is loses, there is absence of the moral principle, there should be a harm or a certain problem. Second aspect I would like to put here, that is worship is going on throughout India, right? In worship, so well, Bilava, it's a Quranic name Bilava. Bilava is used for the sheep worship, right? Similarly, Ashapta, Vata right? People ka pair. It is a Sachi 24-hour oxygen providing. Mango tea, 12 hours. After the sunset, mango tea will not provide oxygen. It will provide nitrogen. Nitrogen is harmful for the human body. Oxygen is friendly for the human being. What I am suffering now? Because I am suffering COVID. There is oxygen circulation in my body definitely. has created some problem is there. Therefore, my cold has come. So, Ashwatha Vriksha is very essential for Vishnu worship. It has been that directly or indirectly, Indian society was engaged with the protection of environment, right? But why these things I am mentioning? In this juncture, I would like to mention that every law have two approaches. One approach, non-anthropologic approach. Another is anthropogenetic approach. Modern society or human rights law is mostly rely on the anthropogenetic approach, which is the side effect of the society. Anthropologic approach means only the human being is the center of discussion or protection. This human being cannot survive without the earth, without the water, without the sun, without this one. Electricity is not enough. Sunlight is required. Right? From where sun is coming? Beyond the sun is there nothing. We don't know. Therefore, Shankaracharya say that Brahma, that is Brahma Sattva Javarpita. Brahma is so big, I cannot explain. I don't have my figure, I can explain this length is 10,000 kilometers. My length, right? I cannot have any size to tell that it is Brahma is more than globe. You can correlate, you can put together a globe that is Prithvi and Moon, then Brahma. That is his Ashim and Shashim. That is, there is no language by which I can explain. But here, the main thing of my discussion is main summary of this ancient period. In ancient period, the practice was non-anthropology. That is, the approach was other than the human being, you protect, then you will be protected. Other than human being, what? Agni, Vayu, there is five panchata. Right? What is anthropology? Anthropologic value is that only you concentrate on the human being, protect the human being, then you will be happy. No. Human being alone cannot work. Non-human being is the much more. 2/3 of the globe is surrounded with the water. Water, what is it? Non-human being. Right? So Ganga Puja hota hai, right? Varshik Puja hota hai. Similarly, Vayu, that is air. So in this way, we are shifting from one approach to another approach, and whenever the shifting is taking place, disasters are taking place. It may be in favor of you or it may be against you. You look into the rocket science. When rocket crosses the earth, there is a blasting, right? Then scientists are very careful. There is one situation when you cross the one situation to other, and it will happen in your life. I have come across. My students have come. Earlier, my students, they were the student. Then they become teacher. So, orientation. So, how a teacher should work. How a teacher should talk with a student. How a student will talk with a teacher. Because there are confidentiality. This teacher who is talking to you, he may be a question paper setter, but he will not disclose you. You can ask sir which question is important. He will answer this and that. He will not tell the original thing. And subsequently you think, my teacher, I so respect him, never tell that this question is that. He's correct, you are wrong, your expectation is wrong. So your expectation and your receiving, there is a gap, you will come and put it back. This is not the final thing. The final thing is that what reality is what your teacher could have done. So in this background now I'm coming to British. British people have been criticized over the time because we are Indian, we fought freedom struggle to make India, mother India, to freedom, get the freedom, and to develop our own political process. And we have developed also. But question is whether anti-British policy was wrong for environmental. I am concerned here only the environmental. And environmental is not alone, it is linked with other law also. So, in British people, they developed policy first, then enacted law, they developed the infrastructure. Three things. I welcome all the creations. Infrastructure is required to implementation of the law. What they did for the first time in 1806, they developed the forest department. They have appointed conservator of forest in India. It is their post. Now forest, Indian Forest Service is there. For example, Indian Police Service. For example, Indian Civil Service. Similarly, Forest Service is there. First they developed a department, forest department. Then between 1820 to 1865, they issued number of notifications, government orders, and made certain trees exclusive their control. What are these trees? Teak. Do you understand teak? लकड़ी होता है. Teak very costly. Furniture के लिए बहुत अच्छा है. Teak, rosewood, anjali, chandan. These are certain trees. They are notified and they said that you cannot cut down these trees. It is their control. Then in 1865, Indian Forest Act was enacted. Right? So how long take time? First, that is infrastructure. Infrastructure means forest department. Then certain identification of the forest. Then the act was enacted. Forest Act 1865. Heavily criticized by the Indian people that these acts are nothing but an instrument to exploit the Indian forest for the British Parliament, right? Because they have developed the monopoly. जंगल में लकड़ी सिर्फ ब्रिटिश काटेगा और उसको बेचेगा भी वो, right? And Indian people found that वो बेचता भी है, इंडिया में भी बेचता नहीं है, ये बेचता है लंदन में, अमेरिका में मार्केट में. उसका पैसा कहाँ जाता है? उधर नहीं आता है, वो पूरा लंदन में चले जाता है. महाराष्ट्र. So after this protest, so first protest how it came from Calcutta, where I teach. So Warren Hastings was appointed as administrator by the, and he developed certain policies. CPC policy was Warren Hastings. So one judge was appointed in the High Court at Calcutta, right? So every evening he had a meeting with the Chief Justice, Jamba. Lunch, dinner, दोपहर में भी बोला जाता चला जाता था Chief Justice का High Court. So Indian people was also learned. They said that it is a gross violation of the rule of law, judicial separation of power, and it is a gross violation of the separation of power. And matter was reached to the British Parliament, and one impeachment proceedings was moved by the then famous barrister Edward White. He into the he moved the impeachment proceedings and successfully he impeached him only on the ground of the rule of law, right? And he has violated the British parliamentary trust. He has been removed. Warren Hastings was removed. So in 1865, in 1860 was very important and discussed because in 1860 Indian Penal Code was adopted along with the CRPC, right? In 1865, Nanda Kumar was hanged by ex post facto law. So, and this process appeal was filed in the British, filed in the House of Lords on the ground of the violation of the rule of law, right? And Warren Hastings was impeached. And impeachment proceedings was written by Edward Barr that 1 month, 9 days before an incident was happened, upon which nobody can speak nor be silent. This incident was the French Revolution. France Revolution जिस दिन डिक्लेयर हुआ, उसका just 39 days after impeachment proceedings was. During this time, British Parliament was in a big period, that is, with a new act, Forest Act 1878, right? But 78 is not a 1878 Act is not a liberal act, rather more rigorous act than 1865. Then again, the Act of 1927 was enacted. First Act of 1987 was enacted. So as a result of three acts has been enacted, the policy has been developed, its infrastructure has been developed, and as well as the legislative mechanism has been developed, and three things has been developed over the time: conservation of the forest, preventing destruction, and promoting the development of forest. Right? There are these three. As a result of these three acts, there is conservation of forest policy was developed in India, and you cannot deny that the conservation of forest policy was not useful for Indian benefit also. Still now this conservation policy is in force. Now Indian people realizing that for environmental protection, conservation of forest is required, right? So it is the forest policy, and without the forest conservation of the forest, environmental protection of law is impossible, right? Panchatattva is not possible to be protected. One missing point I find that Indian mythological practice was based on non-anthropologic approach, but British people's policy is based on the anthropologic approach. Right? So I am coming again to the British development which stayed in force. Recently, Parliament has also repealed three legislation. One is IPC, CRPC, and evidence has been repealed, and new name has been given. But whether this repeal, so far as the environment protection is concerned, is there any variation? New thing has been introduced, or only the bottle has been changed? Right? It is the question. So, two cases I like to put before you. One has been decided in 1856 when British parliamentary system was introduced. 1857. So in 1850, 1 year before, one case has been decided by the House of Lords. The name of the case is Attorney General versus Lords. In this case, and another case has been decided in 1858 after 1 year of the British fire. Before that, East India Company was taken the charge of administering India. East India Company became active, right? And from company, political process has handed over from the company to the British Parliament. So both of these two cases has created the law of nuisance, right? What is the fact of these cases? That is, during the time of the British colonies, that is, city or township has been developed. So from the town outlet system, wasting system, drainage system out to the river. So from this drainage system, leakage took place, and the result some harm was taken. So there was no any law to give remedy. So House of Lords says that no, it is the public suffering. So certain public law is required. What is public law? They say that it is a nuisance that creates. The law of nuisance has been developed. Therefore, they will be remedied. Those who suffering from the leakage, water leakage, and this same fact has took place in Bhopal. In Bhopal, that is gas leakage in 1884. Bhopal gas leakage, and Ratlam Municipal Corporation case was took place. Same IPC and CRPC jumped, right? What was the principle of the law has been applied? It is the Attorney General versus Bhutan case. So, as a result of which, two cases have been decided, and positively court said that yes, it is a nuisance, public nuisance in the area of law. It has to be developed. So, in 1860, Indian Penal Code has been enacted in India. So, whenever a law is enacted, its side effect is there, and under the Indian Penal Code, capital punishment, hanging process, death penalty has been imposed by Nanda Kumar of Calcutta, and he was hanged. Argument was the law is forgery made crime under the Indian Penal Code, which was enacted in 1860, came into force on 1861. But forgery took place in 1858. So, criminal law cannot be imposed retrospectively. Therefore, it is wrongly impeached. But hanging took place. So, it is called a judicial murder. So, you can call them judicial murder, but they were successful to impose the law. So, 260 to 294, detailed provision of the law of nuisance has been developed under the Indian Penal Code. Still, these provisions are in force, right? So, why are these provisions now? Under the Bharatiya Nyaya Samhita, 2000, after Indian independence, and after Indian independence, new CRPC was CRPC of 1973, right? So, what is now provision? This CRPC provision is now name of this CRPC is Bharatiya Nyaya Suraksha Samhita 2020. And under new provision, sections are 252 to 264, executive power. Really useful for giving at least small relief, right? Small relief under the criminal procedure code. Now I am coming to post-independent India. All law